When one or more individuals acquires title to real estate, they can do so in a variety of ways. Most often, when a married couple acquires title to property, they do so as joint tenants with rights of survivorship. And that phrase, rights of survivorship, essentially means that if one spouse passes away, the surviving spouse, who is also then the surviving joint owner, becomes the sole owner by operation of law of that property. Same concept applies if there are, let's say, 3 joint owners with rights of survivorship. One of them passes away, the other 2 are left with an equal interest in the property. Okay. I'm attorney Jeff Cooper. I got a quick client story for you about some unintended consequences. This is a married couple who got married later in life, a second or subsequent marriage. They actually acquired title to the property. They purchased a house together prior to their marriage. And what happened was whether they did it intentionally or not, possibly they did so as tenants in common. And for some reason, they never changed that designation after the marriage. Marriage goes well till one of them passes away. And at that point in time, upon the death of the second spouse, according to their plan, what they wanted to have happen was for the adult kids of the husband to inherit everything. And I'll give you a minute to pause and comment below if you want, if you think that's exactly how it went. No, of course not. I wouldn't be here telling you the story. I wouldn't even probably know this client. I ended up doing a little work on behalf of one of the kids of the husband. What happened was a portion of that interest then went to the survivors of the wife. And that isn't what they wanted. Now, to be fair, not that joint ownership would have necessarily solved the problem. Let's say the husband died first, then all of it would have gone to her, according to her plan, right? Point is that there were some unintended consequences there that they could have addressed through a little more detailed planning. Another point I would make is that if you're in a second or subsequent marriage, especially with adult children, especially if they don't know each other, or especially if they know each other and don't get along. In other words, if they weren't raised together, didn't grow up with one another, there is kind of naturally a lack of trust sometimes between those parties. And so, if somebody's in that situation, they necessarily have a more complex planning landscape than somebody who is on their first marriage, or all of their kids are common to both of them. Generally with those folks, it's more predictable, I guess, that their interests are 100% aligned in terms of who they want to inherit from them. So, if you're in that situation, I would definitely just take a detailed look at what your plan does and how it functions, and just make sure that everything's in order. So thanks a lot.